My name is Paul Witt. Good afternoon, everyone. Thanks for joining us today. If you have any difficulties hearing me or seeing me or seeing the presentation, please drop a note in the chat box. My name is Paul Witt, and I am an attorney at Lewis Thomason in Knoxville, Tennessee, and I'm a member of the construction practice group. And we work on cases across the state. We have offices in Knoxville, Nashville, and Memphis, and very active in the construction community and construction claims across the state. A little bit of background: I've been in this practice for over a decade now. I've been practicing for over 16 years. But for past about 11 to 12 years, primarily focused in construction and construction-related claims. A lot of my work has been for designers, architects, engineers, but I've also done quite a bit of work for contractors, owners, and other project construction industry participants. What we're going to talk about today is project management, and mostly project documentation, and what we have been able to identify as some best practices and some practices we'd like for our clients to avoid. And they're really based on what we've seen in our practice, in cases that we've been defending or we've seen mistakes that other parties have made. A lot of this is somewhat common sense, but it's always good to be reinforced. And some of it you may not understand or may not have thought about before, or understand exactly why it's important to handle documentation the way that we're going to talk about. And also, these issues really permeate just about everything that we do in our practice. Just about every case I have has a documentation or a project management issue. Sure, sometimes there are cases where it's clearly a mistake has been made, and we're talking mostly about what are the costs to correct it. And obviously, there are some times where the claims are just bogus, just unfounded. There's no reason for them to have been filed, and we have to work on getting them dismissed. The vast majority of the cases actually fall somewhere in the middle, where there's some sort of project management, project documentation gap or failure that we're having to work through, where there's an ambiguity or a hole in the documents that the parties are able to dispute because there's not that good document that actually shows exactly what happened during the project or who was told what during the project. And so that's when the lawyers get involved, and we have to spend obviously all the depositions and interrogatories and all that stuff getting to the answer of what could have been explained with a during project document. So that's what we're going to talk about today. I think the way to post questions is in the chat box, and I'm going to try to see if I can access that. But I will address those questions at the end if I can. So I'm going to try to advance the PowerPoint. There it is. So construction documentation. So to me, that's somewhat synonymous with project management, especially in a construction context. And again, you can see kind of an old cartoon, but I think the wisdom kind of rings true, that sometimes the low bidder just is not the best way to go. And I'll say that, the low bidder, kind of shows up a lot of times, not just in what I call sticks and bricks, but it also can show up in papers and emails and the way that the project is managed. What is construction documentation, and why is it important? Well, the first and most kind of obvious one is that a clear documentation in real time is our best defense tool. It's the most important risk management tool that we have in construction claims and defense of construction claims, or prosecution of a construction claim, whether that be a delay claim or liquidated damages or something like that. This applies both to defense of claims and prosecution of claims. Also, if there is a careful and a complete record of the project, that's the first thing that we're going to look for, and that's the first thing most likely that we're going to start advancing in the case, even if it's not in litigation. As soon as it comes in, we're going to be asking for, hey, what's the contract? What does it say? Has it been amended? Have the contract, have any change orders or amendments been memorialized into signed agreements, signed change orders? If there was an issue during the project, what was the communications about that issue? How were they resolved? We're going to ask for the documentation probably during our first conversation. And I'm going to be looking at that. And if I can have a document to go back to the other side and show them this was documented, this was resolved, this was agreed upon, then we're going to be in a much better situation to defend the claim or potentially resolve the claim, even if we're on the affirmative side. Some of the good examples that we've seen recently in some of our claims, for instance, like in terms of like a contemporaneous documentation of issues. For instance, a designer who's responsible for a stormwater repair project, and there's a question about the selection of materials, whether it be stone or other aggregate that are going to be used in the project. The owner wanted a unique setup in terms of who was purchasing the product, because they were going to get a little bit of a discount on the purchase if they or on the product if they purchased it themselves. But the contractor still needed to be responsible for the selection of the materials, because the materials became very important in the actual performance of the design. A very good example of contemporaneous documentation was, in that case, the designer actually put into the specifications, as that change was being implemented, that the contractor still had responsibility to select and install the correct materials, even if someone else was purchasing them. Ultimately, that became a bit of a point of contention when there became an alleged issue with the performance of the project, and we were able to go back to that specific change in the specifications and show it to the contractor and say, look, you were still responsible for the selection of the materials, even if the owner was purchasing them. And so it really turned the dynamics of that claim on its head and allowed us to resolve it very favorably. Another example, not in a construction context recently, but in a closing on a purchase of a piece of property, there was a question about the timing of closing and delays in completing the home. The homeowner who purchased the house filed suit asking for all of these extra living expenses because the closing was delayed 2 to 3 months. And while it wasn't the largest claim in the world, we were able to go back to the transaction documents and see that at the time of closing, when they actually decided to purchase the house, the parties involved, these were real estate agents, thought through it enough to think, well, we're closing this after the contract closing date shown in the agreement. We need to document that everybody here is in agreement that this is a proper closing date and that we need to amend it to extend it out through today's closing. They documented that. We had a signed agreement from both sides. When that suit was filed, first thing I did was ask, what documents do we have? They provided me with that document signed by both sides, very clearly showing that the closing date was extended through the actual closing date, showed it to the other side, and that claim's going to go away because we were able to go to the project records, to the transaction records, and find that documentation. Another area that we see documentation become an issue, most of the time we see it actually in a positive manner. We think that is substantial completion. Tennessee has a very short statute of repose for construction projects. So any claim relating to the construction or of an improvement in Tennessee is subject to a 4-year statute of repose from the date of substantial completion. That means after the project is substantially complete, which means when it can be used for its intended purpose, anyone asserting a claim against the contractor, the designer, the architect, the engineer, anybody really other than the owner, they have 4 years to assert that claim. And after 4 years, regardless of whether or not the person asserting the claim knew about it within 4 years, the claim is completely wiped away. So the statute of repose is a very strong tool for contractors and engineers and architects and other designers in Tennessee. Documenting when the project was substantially complete, when it was able to be used for its intended purpose, is absolutely crucial. Now, we see most of our architects and engineer clients understand that, and they document that very carefully. But even if you are a contractor, document that. Know when that project has been completed so that you can go back and say, that clock began running on this date, so that if there is a claim down the line 4.5 years later, 5 years later, 6 years later, we can go back and say, no, that project was substantially complete more than 4 years. And that is one of the strongest weapons we have in getting rid of construction-related claims. Now, what I guess on the inverse, claims can obviously be severely damaged if there's not good documentation. So for all the good examples we have of very clear documentation, we've got a lot more of claims where there's not a good, clear smoking gun document. For instance, recently we had a claim involving, let's just say, the construction of a large container that was going to be outside, and this container did not need to suffer any water intrusion. That was a very key component to the design of this container. And the plans showed that this container, it was going to be stacked on top of each other. They're going to be 3 segments, very long, let's say, many feet long and many feet high, but they're going to be stacked on top of each other, and they were going to be connected to each other at flanges or seams. Well, the designs called for those flanges or those seams to be seal welded from the inside. And it was very clear. It said, if this container is going to be installed outdoors, you need to seal weld them from the inside. Well, the manufacturer of this container wasn't selected to be the person to install these containers. The owner selected really a low bidder, and we worked through that issue. And during the beginning of the project, there was a question as to whether or not they could avoid the cost of seal welding these seams or flanges, and instead bolt them together and use kind of a gasket or a caulk. As we understood it, the communications at that time were from the designer and the manufacturer of that container that, no, you still need to seal weld them. But if you do elect to not seal weld them, then look, you need to bolt them. You need to get the gasket on there very well placed. Obviously, you can imagine there became water intrusion events down the line, and the owner of the facility started saying, well, you should have told us that these things needed to be seal welded. And we knew that communication had happened where they said, no, you still need to seal weld them, but if you elect not to follow our recommendations, your next option is X, Y, or Z. We just didn't have that good, clear document. There wasn't an email, there wasn't a meeting minute, there wasn't any type of field report that showed that this discussion had happened where they were strongly encouraged to still perform the seal welding. So we had to go through the whole process of digging through thousands of pages of construction documents, project correspondence. we were able to build a good narrative that showed that this recommendation, excuse me, was made by the manufacturer or the designer of the container. But it took a lot more work than if we were able to go back and show, look, here's when that person told you at this project meeting, at this weekly meeting, that the recommendation still was for seal welding. If we had that, the claim would have gone away much easier and much less costly. So what are some of the additional reasons? So for project documentation or construction documentation, expectation setting, memory, making sure that you can convey complex thoughts and information during a project. And then also, from our standpoint, proof. What is expectation setting? Obviously, in construction projects, disputes are often going to arise from unmet expectations. In that same container dispute that I mentioned a minute ago about the water intrusion and seal welding, there was another dispute that we had to contend with because we didn't have a really good document to lean on, and that was the supervision of the installation of that container. Again, this particular party had the responsibility to manufacture this container, and typically they install the containers themselves. But this particular facility owner decided to use a lower cost local installation contractor, but they still wanted the manufacturer of this container to supervise the installation. Well, the contract had already been signed for the manufacturer of the container to actually install this large container at this facility. So they had to amend the contract. And when they did, they put in some language about that the manufacturer of the container would provide so many hours over so many weeks of installation supervision. But they never said what that included, because there was another provision of that same rider, they called it, on the contract that said that the manufacturer of the container had no responsibility for the quality of the welds of the actual installation contractor. But there was that language in there that they were going to provide some installation supervision. And so throughout the claim, there was a large dispute and a lot of work put into kind of reconstructing what type of supervision was actually provided by the container manufacturer and what type of supervision was expected by the facility owner. And so if we would have had a document when the contract was changed to take the installation out of that particular scope of contract, if we had a document that showed exactly what the expectations were for the installation supervision, we again would not have had the problem of dealing with the water intrusion dispute, because we could have went back and said, look, the installation was not our responsibility, and we met whatever our obligation for supervising the installation. Instead, the facility owner, was able to craft an argument that the manufacturer of the container had a lot more expanded supervision responsibilities than what the container manufacturer expected. Ultimately, again, I think the narrative that we were able to reconstruct through pouring through thousands upon thousands of pages of project documents revealed that the container manufacturer did in fact provide more than adequate installation supervision, probably gave them about 3 or 4 times the amount of installation supervision that they actually were required to under that contract amendment. But yet the container manufacturer still had to go through a large volume of litigation and expense to deal with it. You can also deal with expectations in proposals and contracts, drawings, the technical specifications, and obviously other construction documents. It's kind of goes without saying that, you know, your contract sets the stage, and you know, that is so basic that you would think that that never becomes an issue, or is not often an issue, but we see that more often than you would expect, to where on a very large project there's just simply not, either sometimes just simply not a contract at all, and the parties are just operating in the wind verbally without a written contract, and you can guarantee that that case or that project is most likely going to end up in some sort of dispute, some sort of litigation. Those are the worst projects to defend, is when there's simply not a written contract and everybody has their own version of what the agreement was or was not. So if you have a situation where you think, well, this is a person that I know pretty well, we don't need a written agreement, we don't need to follow all those formalities, that's exactly when you need to go back to your office, pull out your form contract, and sign that contract with that person, even if it's one of your best friends from growing up, even if it's a family member. Because I can tell you, I've seen people who thought they would never be in a dispute with a particular person end up in multi-year litigation over a verbal contract. Always document your contracts. And also, if you have any type of amendments to your contracts, make sure you document those as well. Don't ever get lax and think, well, this is not that important, or this is not the way we've been doing it on this project. Always follow a written change order process. Also, another reason that construction documentation is so important is memory. Most of these claims don't happen just a couple of months after the construction events take place. They typically happen several years down the line, sometimes 7 to 10 years down the line, especially if you're looking at actually getting to depositions or trial. It's going to be multiple years after the actual events take place. So having documentation of what you said, when you said it, who was involved, what type of backup you gave them, is going to be absolutely crucial. Whether that, I mean, obviously the best example is having a good solid email. You can go back and pull up and say, well, I know I sent them this drawing on this date, or a change order. Said, I know that we made this change order on this date, and make sure that they're signed. Don't just think, well, just because I sent it to them, that it's, you know, that, well, they had to agree to it. If it needs to be signed, if it's a change order, if it's a contract, make sure you have a signature in your file that shows that they actually agreed to it, so that if you ever do have to raise that or call them out on it, you can pull it out and you can show their signature. Obviously, the documentation is also going to be easier to help people remember lots of information. Some of these projects have many different angles going on at all times, especially if you're a designer or an architect. Being able to go back and see exactly what you were dealing with and what you told, you know, one of your consultants, or you told, you know, a construction participant. Documentation is crucial. Another example is that construction documentation allows people to convey inherently complex information, and also activity that is very information intensive. The next example, and the one that we see probably the most, in addition to memory, in addition to being able to go back and have some type of institutional knowledge of the project, the construction documentation allows us to actually prove what happened. And again, I said just a few minutes ago that a court case, or even an arbitration proceeding, is going to take place typically multiple years after the project was designed, after the project was constructed, and even after it was completed. So you're going to need the documentation to be able to go and present credible proof of what your instructions were, what the actual agreements were, what the information that was supplied during the project was, and also events that happened during the project. The judge, the jury, the arbitrator, whoever your fact finder is going to be looking for documentation. They're going to be looking for paper, emails, contracts, change orders to actually support what you say happened during the project. And again, witnesses themselves are going to have a lot of difficulty remembering what happened a long time ago, even if it is a situation where it's not like a change order or a contract. If you're just trying to remember what happened on a particular day or what happened during a particular event in the project, having proof, having documentation of that event is going to allow you to go back and kind of reconstruct, recreate those events many years down the line. One of the best types of this type of information is either a field report or a daily report, or an email that documented, hey, here's what we talked about this day, here's what we saw when we did our site visit, here's what we told you guys needed to do. You needed to correct this, you needed to clean up this, you needed to replace this. Allowing that witness to go back and refresh his or her memory with a document is incredibly important. Another thing is that sometimes witnesses can pass away. They can move away or just become unavailable. And if you have a document that memorialized what happened on a particular day, there are ways that we as attorneys can get that document into evidence at the appropriate time, even without that particular witness, if they somehow passed away or they're not available or they're just basically uncooperative. They're, a daily report of work that took place on a particular day and was recorded contemporaneously with that work can be admissible as what's called a business record. And so if there is that level of documentation down the line, you won't be subject to the potential whims of a witness, maybe an ex-employee who no longer wants to help your company, but yet their documentation is helpful or their memory of a particular event would be helpful. If you've got a document from them, then you can actually use that to support your claim or your defense many years down the line. Another idea or another aspect of this is even the most likable witness can sometimes be found to be viewed to be biased if they all of a sudden have lots of information, lots of details that they're able to recall. If you can show that they're actually being able to look back and be confirmed by a document, an email, a daily report that was created in real time that backs up what they're saying or that is in line with what they're saying, you can really combat any perception of bias when they're giving their testimony. Again, so it goes to that same point that being able to show that a person's knowledge is supported by contemporaneous documentation will allow you to beat back any argument that this witness is just trying to help the architect. That the architect is trying to support their position, and this witness is just trying to be helpful to that person. But if you're able to show them, well, no, this is what they thought at the time. This is what they documented at the time, long before there was a dispute, long before there was a reason to take a position on this issue, then you can combat that issue of bias and make your claim, make your defense much more persuasive. But what's also important is to make sure that when you're doing this, you're not documenting opinions or emotional reactions, that you're just documenting facts. Okay, don't try to insert any opinions or other conclusions that you're reaching about facts. Just document that they had 5 people here today. We told them to undercut this dirt by 5 feet and replace it. just document exactly the conversations that took place, and nothing else. Again, if there is a change in the contract, if there's a change in the specifications or the design, regardless of where you stand in the project, kind of lineup, whether or not you're the architect, you're the engineer, you're the contractor, you're the supplier, you're the owner, make sure that if there is a change, that it is documented in stone. I cannot emphasize how important that is, to make sure that if there is a change, no matter how small, that you document it. And if the contract requires a particular method of documenting that change, make sure you follow it. It doesn't matter if that's not the way you typically do it with this particular contractor or designer or owner. If the contract says that that all changes have to be in writing, follow that. Do not rely on, well, they'll agree with it, if we ever asked them about it, or the judge just simply, is still going to give it to us because they know we did the work. Don't ever rely on that. Document it in stone. And a large part of this is because there is this perception, especially in my line of work, that if there's a significant event in a construction project, it's going to be captured in some document. I'm going to be able to find it in a daily report. I'm going to be able to find it in an email. I'm going to be able to find it in a weekly meeting minute. I'm going to be able to find it in a change order. If you don't have the documentation, you're going to be fighting upstream to explain why there wasn't documentation of this change. And again, bottom line, if anything of importance is not documented, it did not happen. Now that's not a legal rule, but that's a kind of a rule to live by. That if you might as well assume that this is going to be enforced, or this is the way it's going to work out if a claim ever arises. So just assume that if there is something of importance and it's not documented, then it's going to be nearly impossible for you to prove that it happened. This is a graphic that one of my colleagues came up with in the context of employment litigation, and it's very similar to construction cases in terms of documentation. And the point that he's making with this graphic is that one document is better than or equal to 10 witnesses. And the idea is that if I have one document that says that we took this out of the scope of the contractor's scope of work, and they're not entitled to payment for this work. And if I've got a document that says that, that's better than bringing in 10 people to say that, yeah, that's what happened. Okay, that one document is so vital, so powerful that it will overcome the other side trotting in 10 other people to rebut it. So the idea is one document is really better than 10 witnesses. So probably should be a greater than sign there rather than even an equal sign. But again, say it again, one document is equal to or better than 10 witnesses. So the more documentation you have, the better. And again, it's common sense, but it's something that we see repeatedly in our practice. And it's something to just kind of just be hammered home that you have to follow the documentation process. What are you documenting? These are just some examples of things to document. So from program documentation, from the design standpoint, make sure that you're documenting the government review. Make sure you're documenting any owner or government approvals, especially if there's a regulatory or contractual obligation to get those approvals. Again, make sure you have written contracts and written contract amendments. I've, in the past couple of years, I've had some of my largest claims over really large construction projects where there was not a written contract and the disputes were like we're talking about in well into the 7 figures of claims on projects where there was not a written contract. They thought that we're friends with this person. I've known him or her for a long time. They wouldn't do us like that. And sure enough, they did. And they had no written contract to go back and fall on to know where their responsibilities began and where they ended. Another area that we see where contracts are really not followed through on, surprisingly, are architects. Architects, while they're really good about making sure they have their contract with the owner, and they're also typically really good about assisting with procuring the contract between the owner and the contractor. Where we see a big gap and where it ends up being a problem pretty regularly is when the architect hires the consultant, whether it be the mechanical engineer, the structural engineer, what other consultants they may have. So oftentimes they just fall down on actually documenting that relationship, or if they do, it is a very cursory, very simplistic agreement, almost like a letter proposal. Sometimes that's the best I see, is just a letter proposal outlining what the consultant has agreed to do and what the price is. If you are a designer, if you are an architect, make sure that you are still going through the same process of memorializing your agreement with your consultants as you would with your owner. And I've luckily we've been able to pass off some responsibility to consultants even without written contracts. But if we had a written contract that actually had kind of a risk shifting provision that are typically seen in those types of contracts, it would have made the claim much better. It would have put it in a position to where the architect's insurance didn't have to respond so much. We could have pushed it off onto the consultant much easier. But again, shockingly, contracts and contract amendments are missed more often than you probably would ever imagine. The gold standard is, if there is an amendment of the contract, that you get a signed change order, a change order that's signed by all relevant parties. If it's, if you've got an owner with an architect and a contractor, get all three of them to sign, okay? But all the interested parties, make sure you have a change order that documents exactly what is being changed, what is the price, what is the time change, and and that it refers back to the original agreement. Get that in writing, store that away safely, and don't make changes to the contracts without it. That is the gold standard. If you can't meet the gold standard, an email documenting it and getting an approval back, we can work with that sometimes. Text messages are probably still, it's kind of going down the list of things that I would prefer. But if I've got something that shows that the interested parties recognized a change and acknowledged a change, then I can work with it. But the gold standard is your standard formal written change order agreement. But I also tell people, if you don't have anything, just and the best you can do is having some type of signature on some piece of paper in the field. Get what you can get. But always try to come back to reducing. If you have an email, if you have just a scrap piece of paper agreement from the field, go back and reduce it to a written change order after the fact. Because there are many, I'm seeing in a lot of contracts, owners or contractors trying to contract around that potential in the field changes to say that in the field changes are not effective even if you perform the work. It has to be a change order approved by a particular person. Now we could work with some type of confirmation that the work was performed and was requested and there was some type of written acknowledgement. But if that contract has that type of language, there's a decent chance that the court is going to enforce it. So go back and at least document it in a written change order after the fact. The best practice or the gold standard is to not perform the work unless and until you have the written change order. That is the best practice. Even if it slows down the project, even if you get some static from the owner or the contractor or whoever you're working for, just explain to them, this is why I have to have this written agreement, is because the contract says I have to. And I appreciate you giving me your word that you're not going to, to shortchange me down the line. But unless I have the written agreement, the written change order per the terms of the contract, I can't guarantee that to be the case. So the gold standard is the written change order. Some legal issues that come up in documentation and kind of a lack of documentation is what I just talked about, that you can't, a lot of agreements have provisions that say that there can be no oral modifications. And those are enforceable. You can get around that at times with course of dealing arguments, but those are complex, those are costly, those are time intensive, and you don't want to rely on that, especially if there's a provision in the contract that says that there are no moral modifications. The other side is going to, the side that has that argument is going to be in a much better position than the side that performed the work with all kinds of promises and assurances that they would be paid for it. That side is going to be at a very, very strong disadvantage, because the no oral modifications rule or provision is enforceable. The parole evidence rule really kind of, is part of the no oral modifications rule. The parole evidence rule is simply a rule of evidence that says that, if you have a written contract that captures the entire contract between the people or between the parties, that parole evidence or oral evidence is inadmissible to change, alter, or modify the terms of that agreement. So you can be faced with a parole evidence rule issue if you're relying on, well, Jim told me to go ahead and pour this extra retaining wall right here. Well, if that's not part of the agreement, if that contradicts what the agreement says, then you may be barred from seeking payment for that by the parole evidence rule. So get a written change order, get some documentation of that agreement so that you don't run into it. Statute of frauds is simply, it's a set of rules across multiple statutes and multiple embodiments of the law that says that certain agreements have to be in writing to be enforceable. And here, contract to purchase a piece of land, contract for the purchase of goods over $500, contracts that can't be performed in 1 year. These are types of things that would be kind of applicable in a construction setting, but the statute of frauds could be another barrier that you run into if you don't have your agreements reduced to writing, if they're not properly documented. Again, so here are the kind of the explanations of the no oral modifications. There's the parole evidence rule. It says it's a rule which states that once evidence or any statement has been given, it cannot be retracted, modified, or annulled by other evidence that might contradict the original statement, apart from a mistake or purposeful fraud. Most of the time, this is viewed in the context of a contract, trying to vary, alter, or modify a contract. Documentation of complex activity. These are just ways that you can document it. Again, I'm going to just keep hammering away the standard change order forms. Correspondence and emails are really good. I prefer not to put substantive or important information in text messages. They're so casual, and they're also really hard to keep and also to capture. So I prefer that if you're doing anything via text message, make sure it is very, very innocuous, such as like, what time are you guys going to be here today, or something that's not substantive to the project. If it's substantive to the project, and even if you have communicated it via text, go back and document that in either a change order, if it is a change to the contract or specifications or anything of that sort, or if it's some type of other project management, document it in an email or a letter or in a meeting minute. And also, if you are using text messages with anybody involved in the project, make sure you are keeping those text messages, because if you end up losing them or not preserving them, then that's another gap of information and big hole of documentation that we will be faced with if there is a claim. Field notes are crucial depending on what type of services you're providing. Photos are fantastic. Photos with dates, timestamps are great. Meeting reports. These are the topics that you should try to capture. Make sure that you get your topics discussed, any recommendations given, any conclusions reached, set forth action items of who's to follow up and by when, and use a standard form. Make sure that you have it all set out to where people know where to look for information. And if you're going to do weekly meeting minutes, which I recommend, especially if you're having weekly meetings, is to do it regularly. Don't do it sometimes and not do it others. Follow through and do it, and create a record of the project, because that will absolutely help prevent and fend off any claims down the line. Okay, so on the flip side of what to document, we also see very regularly examples of what not to document, and this is as instructive as the exhortations to document with written change orders is to make sure you don't put this type of information in your project correspondence or project file. We see this very often, and these examples you're going to see over the next few slides are things that we have seen ourselves. And so fear, shock, anger when you think you've made a mistake or someone in your project team has made a mistake, don't document that. Don't start emailing people. Don't start texting with people. Just remember that text messages are as admissible or as discoverable, meaning that the other side can get their hands on them if a case is filed. If you get pulled into litigation over a project, your text messages with project participants and your own team are going to be completely subject to discovery. You're going to get a letter that says to preserve all your text messages. You're going to have to probably provide your phone to get the text messages pulled down and captured. And so they're going to see exactly what you are documenting, what you're saying via text. Used to, it was emails that we saw the most problematic area where these things occurred, but nowadays it's text messages that people feel that is, if you're texting with it, it's not as permanent, it's not as real, it's more secretive. Well, unfortunately, if there is a claim, there's most likely going to be a stack of your text messages along with other people's text messages that's part of the document production. So make sure that what you're putting in your emails and your text messages don't include fear or shock or anger or other inappropriate comments, whether it be just inappropriate comments or admissions of problems. Resist the urge to create a record until you actually know what's happening. Don't fly off the handle and start I guess guessing as to what's happening. Wait until you actually know what's happening before you start creating a record. Don't start blaming people inside your firm, certainly, and even resist the urge to start blaming people outside your firm or outside of your company. Also, don't do your own investigation or design review or calculations until you actually have a lawyer involved. Most oftentimes what we see is the best thing to do is, if you know that there is a claim, if there is an issue, and you have an attorney that's available to you, reach out to him or her, say, hey, we'd like to have a discussion about this design issue. We would like, could you sit in on it, on that discussion with us? And why is that? And why is that wise, or why is that helpful? is because if the attorney is involved in that, and you've got just your project team, just people inside your company or your firm, then that discussion, even if it's a roundtable discussion between employees, is privileged. Sometimes I have people just call and say, "Hey, look, I'd like to jump on the phone call as I talk to Jim about his design." And so I jump on a call, and they're in the room together, but I'm on the call. That will privilege attaches to that. No one can ever ask, "Well, what did you talk to Jim about when you found out that this system was not, that the loads weren't calculated correctly?" Well, that's privileged. They're not gonna be able to get to that. Same thing, don't start documenting your legal defenses or your settlement strategy until you have an attorney involved. Oftentimes, if you have gotten advice from an attorney and you want to share it inside your firm, one, I would say copy your attorney on it so that the privilege still attaches, and also clearly label that as attorney-client privilege. Another thing that we see people do is they may have an email from their attorney or a letter from their attorney explaining issues with them or asking questions, but otherwise discussing the claim, and they will forward it out to another project participant, another firm, and say, "Well, hey, see what our lawyer is saying here. What do you think about this?" Don't do that, because all of a sudden the privilege has been completely busted. It says here that the privilege may be waived. I say that if you do that, then the privilege has been waived. And also the privilege, and it's not just as to that communication, it'll most likely waive it to all communications you've had with your attorney. So if your attorney is communicating with you, or someone else in your firm or company is communicating with your attorney, keep that inside your firm. Do not send that email to anyone else, or else you will lose your privilege. What not to document. And again, these are real life examples of what we have seen. Admissions of fault. That's probably the first thing that we see. A few years ago, I had an accountant that I was defending on a malpractice claim, and I got her file. It was actually a gentleman, and I started going through it, and one of the first things I saw was this gentleman had written an email, or actually a memo, to the file that says, spoke with X today. They had a question about this particular issue. I looked into it, period. I believe I have a malpractice claim against me, period. And he did a memo to the file and put it in his file. Well, he didn't write that to a lawyer or to his attorney, and that was part of his file. And so when they asked for a complete copy of his file on this particular client, I had to give them that memo. Now, granted, we were able to resolve that for a very reasonable amount, but that particular person created the smoking gun against himself by putting an admission of fault in the form of a memo in the file. Now, that's the most egregious example I've ever seen of it, but you see it a lot of times just in emails or in text. So make sure you stay away from that completely. Even in non-claim settings, stay away from any raising political issues. Stay away from any type of insults, people inside your firm or outside the firm. You never know when that's going to come back to bite you. Obviously, any type of pornography, you'd be shocked at what we see in some of these project files. Internal firm disputes, don't start putting that in emails or even in text messages. Just leave that alone. Probably the worst thing that you can ever do is to put into documentation that you're trying to hide or cover up activity. You talk about taking a defensible claim to an indefensible claim. Is if there's any indication that you're trying to hide or cover up activity, that's what'll happen. Another kind of rule to live by is that whatever you're going to put in an email or a text message on a project that could actually be subject to discovery down the line, if something goes wrong on a project, assume that your grandmother is going to see it. Okay, just use that rule of thumb that you would never put something in an email or in a text message on a project that you wouldn't want your mom or your grandmother to see. Another way to think about it is just assume that that email that you're going to send or that text message that you're going to send is going to be printed out on a big poster board or put up on a big white screen in a courtroom in front of a jury and made an exhibit at trial. If you're not comfortable with that happening, don't send that email, don't send that text. These are some real examples from emails that we've seen in projects, that are just, very difficult to deal with. Seriously be careful about X. They are idiots and will leave someone high and dry. Again, don't resort to insulting project participants, because you never know when it's going to become an issue in a claim. Another example, this was actually in an internal email where they're talking about they don't realize that our plans are a mess. We're missing half of the unit interiors. Sections don't work. There's lots of missing information. This would be a great teaching example of how not to do a project. Well, that's going to be used against you. So don't document that type of information. Really quickly, as we close up, let's talk about document retention, project document retention. Retain your entire project file, emails, notes, hard copies, digital copies, all project files for at least 7 years. And the reason is what I talked about near the beginning, is a statute of repose is 4 years. There's a way for it to get extended to 5 years. I'm not going to get into the weeds on that. But if you keep it for at least 7 years, then there's a likelihood that that claim or that project is no longer going to be of a significant concern. I mean, at least keep it for 7 years. On government projects, state, county, city even, keep everything forever. And the reason is certainly on anything state related or most county related and even a lot of city related work, they're not subject to statutes of limitation or statutes of repose. So those projects are always subject to claims by the state or the county or it can be the city. So if it's a government project, keep everything forever. Private projects, the things to keep even after 7 years are all your sealed instruments, all your plans. Make sure you keep all fully executed contracts, all certificates of substantial completion. It's what we talked about at the beginning. Make sure that you can go back and say, here is the certificate of substantial completion. And then obviously any settlement agreements or releases, okay? Keep those forever. Because those are the things that even after the statute of repose could be very important in enforcing a statute of repose or enforcing any type of limitations period to prevent a claim against you. I'm right at the end of this, and I don't know if there are any questions. I'm going to be honest, because I'm not able to see the questions. Let's see if there are. I'm actually able to see them now. There's no questions. I appreciate everyone attending today. Thanks for being willing to attend on this rescheduled day. And if you have any questions, I believe my contact information was provided in the materials. If we can help you, please feel free to contact us. Otherwise, have a Merry Christmas and Happy Holidays.